Immigration Law Shape the Debate, sponsored by Trinity College London, with me, Lisa Donald, Adam Pipe and Priya Solanki. In this live session, you can put your questions to Adam and Priya and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and hopefully live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please do ask away. If you're watching a replay live, chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within 48 hours, so please do keep an eye out for this. So let's start with introductions today. For those of you that don't know me, my name is Lisa Donald and I'm Head of Business Development and Marketing for Trinity Secure English Language Testing, otherwise known as CELT. During lockdown, we transitioned into a new government contract to provide CELT for the UKVI in the UK, and we are proud to be market leaders in this service. We take pride in looking after your clients in our centres and have a great depth of understanding of the stressful journey and high stakes involved in the visa process to whatever route they are taking to remain in the UK. We acknowledge and have compassion towards that all of your customers are not the same and have differing needs in their journeys. And we work hard and are experienced in offering a tailored service to your clients as they take their CELT with us. More information on Trinity College London CELT can be found on the online exhibition at thesolicitorsgroup.co.uk. Now I'd like to introduce Adam to you. Adam has been a barrister since 1999 and practices in all areas of immigration and asylum law. For many years, Adam has been ranked by Chambers and Partners as one of the leading immigration law specialists in the Midlands. In 2016, Adam was part of the Bar Standards Board's Public and Licence Access Review Task Completion Group. That's a mouthful. Adam was shortlisted for Barrister of the Year at the Birmingham Law Society Legal Awards in 2013, 2014 and 2019. As part of LAW2021 online, Adam Pipe's sessions include Immigration, Asylum and Human Rights Update, the key case law developments of the last 6 months, the new Part 9 of the immigration rules and the general grounds of refusal. To introduce Priya to you now, Priya was called to the bar in 2008. She practices from One Pump Court Chambers in London. She is busy and experienced specialist in immigration, asylum, human rights and nationality law. For many years, she has been cited as the leading junior in immigration, including business immigration, in the Legal 500. The directory she states she is tactically astute, good under pressure, and very persuasive in court. Priya has particular interest in and experience of cases involving gender violence, modern slavery, mental health issues, vulnerable clients, and deportation. Priya's sessions for LAW2021 online include rights of appeal and raising new matters in appeals, challenging sham marriage allegations in immigration law. So to kick off, we will start addressing some of your pre-submitted questions today that we have been receiving from you. I think, Priya, this one's coming to you first. So post-Brexit, what are the rights of extended family members?
Hi everyone. Okay, thanks very much, Lisa, for that question. So, Adam, feel free to add anything that you wish to what I have to say. So, situation for extended family members, and I'm referring here to brothers, sisters, cousins, and nephews and nieces, is that they can't apply to the EU settlement scheme unless they have already been recognised as an extended family member under the EEA regulations prior to the 31st of December 2020. So they effectively need to have a document that already accepts that they are an extended family member. It is possible for them to make an application under the immigration rules if the EU family member is settled in the UK. That would be the adult dependent rules, or indeed an application under Article 8. Adam, is that your understanding too?
Absolutely. No, that is the position with extended family members. I know the wording of Appendix EU has caused a lot of head scratching, but I think that that's definitely the position where we're at, that they need to have had already been recognised or have an application pending under the regulation. So yeah, no, that's my understanding as well.
Great, thanks guys. Adam, I think this one's coming to you now. So do family members of settled EEA nationals have to pay IHS when they make applications to join their EEA nationals?
Yeah, the IHS, of course, is the Immigration Health Surcharge. If the application is under the settlement scheme, so if you're applying under Appendix EU Family Permit, now that provides for those pre-existing family relationships, and you can have a look there at the definitions. I'm just pulling it up in front of me now. There are definitions of family members within Appendix EU FP. So it's the definition family member of a relevant EEA citizen. So if you're applying under Appendix EU FP, you don't have to pay the health surcharge. Obviously, with new relationships, you'd have to apply under Appendix FM. So Gen 1.3 of Appendix FM has now been amended. So actually, if you look at the relationship requirements, I've got it up in front of me, EECP 2.1, one of the categories is that the sponsor must be in the UK with limited leave under Appendix EU. So if you're applying now under Appendix FM, you need to pay the health surcharge. So for those new relationships that come under Appendix FM, yes, you do. If you can still go under the settlement scheme, no, you don't.
Okay, thank you very much. I think, Adam, this one's coming your way as well. So do family members, no, that we've just done that one. So what is the procedure? Let me just get rid of this chat that's just come up. To obtain permission from the family court to submit a current child arrangement order to the immigration tribunal in the human rights appeal where the family court proceedings have been concluded.
Yeah, I think we're always, and I'm sure Priya, you'd be the same, we're always nervous when we deal with cases involving family court orders. There was that case, I think, back in 2019, Mercelin, where was it a solicitor or a trainee solicitor was done for contempt of court. So we're all very sort of careful. And I suppose it's interesting, the question says after the family court proceedings have been concluded, because if family proceedings are ongoing, certainly in the family proceedings, you can ask the family court judge to put a provision within the order that they are certain documents can be disclosed in the in the immigration tribunal. Now, if family proceedings have concluded, so I presume the questioner means by that nothing's in the order. I don't think there's a problem with disclosing orders themselves. Now, there's a really helpful article on free movement that was written by Rachel Francis from Priya's Chambers called Disclosure of Documents from Family Court Proceedings. I think Rachel does immigration and family law. It's worth having a look at that. But certainly, if the order itself is silent, it doesn't prohibit disclosure in the immigration proceedings, certainly just an order can, but any other documents you shouldn't be disclosing without permission. What there is something called the Protocol on Communications between judges of the family court and the immigration and asylum chambers of the first tier tribunal and upper tribunal. What you need to do is at the case management stage, request the tribunal invoke the protocol, and they will then write to the family court to ask for disclosure of those documents. So raise it at an early stage. I suppose a lot of the appeals now will be lodged using the online platform MyHMCTS. I think there are application notices you can do through MyHMCTS, so I would make an early application for disclosure of the family court documents relying on the protocol, and then it's for the court to do it. The protocol is on the judiciary website, so just have a look at that. I don't know if you've got anything to add on that one, Priya.
No, that was really full, Adam.
Excellent. Priya, I think this one is now heading your way. So in an appeal of an EU decision, is the tribunal entitled to consider the best interest of the children where this issue was not raised in the application? Is the tribunal entitled to consider a change of circumstances at the date of the hearing which have not been communicated in advance to the SH8D, Secretary of State?
Okay, so there's two questions there. So the first question is, in an EU appeal, can the tribunal consider the best interests of a child? Now, practitioners, they may or may not be aware of two important cases on EEA matters where human rights issues are trying to be raised. The first case is Arma-Tamor, and it's an upper tribunal decision. And the second case is TY Sri Lanka, which is a decision of the Court of Appeal. Now, what Arma-Tamor said is that where an individual has got a decision refusing their claim under the EEA regulations, unless they have been served with a Section 120 notice, and there's no EEA decision to remove them, they cannot bring a human rights claim as part of that EEA appeal. What they effectively said is that it completely changes the nature of the appeal that is before the tribunal. Now, in TY, what was argued was that the applicant had a particularly strong human rights claim, as well as having this appeal against a refusal of a derivative right residence card. And the Court of Appeal said, regardless of the strength of the human rights claim, it's a wholesale change to the nature of the claim. So unless the client has been served with a Section 120 notice, which allows them to raise anything further that they wish to in respect of their circumstances, they're not able to raise human rights issues in EEA appeal. Adam, is that your understanding? Is there anything you can think to add to that?
Yeah, absolutely. I think, say, that, or in a deportation matter, we wouldn't be able to raise it, certainly.
The second part of that question, Lisa, is, can the tribunal consider a change of circumstances that you raise at the date of the hearing, that you haven't raised in advance to the Secretary of State? Now, those that practice in immigration and that are familiar with appeals will be aware of Section 85 of the Nationality, Immigration and Asylum Act 2002. And what that effectively says is that new matters cannot be considered by the tribunal unless the Secretary of State gives consent. Now, there's been a lot of case law in respect of new matters, and I have addressed that in the webinar that I've delivered for Law 2021. But one of the cases that is worth looking at is the case of Mahmood. Now, Mahmood basically breaks down the questions that need to be asked. So, first of all, is there a new matter being raised? Now, a new matter has to be something that constitutes a ground of appeal under Section 84 of the 2002 Act. It has to be something that hasn't already been considered by the Secretary of State in their decision. It's not simply you providing better evidence of the same circumstances. It's a different factual matrix that could constitute a new ground of appeal. So, for example, a client entering a new relationship, and that relationship being a qualifying relationship that might meet the requirements of the immigration rules, that would be a different basis on which your client's human rights appeal should be allowed. So it's worth considering that case in full, but it's not advisable to leave change of circumstances to the day of the hearing. As soon as you're aware of that, you would want to communicate that to the Secretary of State. They have a very helpful policy document called Rights of Appeals, and that sets out the approach that the Secretary of State should be taking to new matters. Generally speaking, looking through that document, in most cases, they should be consenting to new matters being heard. That often isn't the approach they're taking, but if you write to them in advance and you alert them to their own policy guidance, then it may well be that somebody sensible takes the right approach, or that if you do it early enough and you get a negative response, that you can litigate that properly by pre-action letter and judicial review before your client's appeal is heard, so that everything can be heard together. Adam, can you think of anything to add to that?
I just agree with you. Raise it. I've got a case coming up. It's back in court on Friday, and we've been trying to get the Home Office to address the new matter. I think appeals skeleton arguments are a good place now to perhaps flag it up and make it clear. And again, raise it on the MyHMCTS, because that might get the tribunal to give directions for that to be considered. There is a case on EEA appeals and new matters by Judge Plimmer. I'm going to mangle the pronunciation now, Oxazoglu. So have a look at that, and that they do, the new matter provisions apply to EEA appeals under the regulations. So yeah.
Brilliant. Thanks both. Adam, I think this one's heading your way now. It's coming from our audience today. So following on from the EEA question, I have had a client who was recognised as an EEA partner and granted 5 years permit.
Yep.
The EEA national then left the UK. So what is the position of the family member?
That's a good question. Obviously, traditionally, EEA documentation does not confer rights, you know, so documentation under the immigration rules, you get your indefinite leave to remain, that documentation confers the rights. That the EEA documentation just sort of recognizes underlying rights. So once they've left the UK, unless they can apply on a retained rights basis, I think their position may be in some jeopardy, and they would need to regularize their position. Obviously, they would need to apply under the settlement scheme anyway. So people with old EEA regulations documentation need to be applying under the settlement scheme, unless they're going to be, unless they've got some sort of retained right. I think they need to be looking at then switching to applying on an Article 8 basis, on a private life, on their own, on basis under the immigration rules, unless they've already sort of achieved a permanent right of residence because of the time they've been here. That's quite a general scattergun sort of answer, but without getting into the specifics, I don't, Priya, had any thoughts on that?
No, I mean, the only thing that occurred to me is that they might have rights under the EU settlement scheme.
Yeah.
Obviously, you'd need to know the precise facts of the claim to be able to advise on that properly.
I think that's right. Yeah.
Okay. Excuse me. What is the status of clients whose EUSS applications are pending even after the 30th of June 2021? I'm not sure who wants to take that one on.
I mean, I'll start it, Adam, and you can add to it. I mean, their applications obviously have to be determined. If they have submitted them prior to that date, then obviously that they'll have to consider them properly. It will all depend on the sort of application that you have submitted and whether you're somebody who was in any event eligible to apply before that date too. I mean, as I've explained at the start, extended family members, they don't have rights under the EU settlement scheme unless they've already got documentation that confirms that they've already been accepted as extended family members. But otherwise, if they've made valid applications under the EU settlement scheme, the Secretary of State will have to process them post the 30th of June.
Okay, I think this one might be heading your way as well, Priya, but I'll let you guys decide that. So are there any new developments with HR applications where no children are involved and the applicant is applying, I think that should say, as the partner of a settled British national?
I get the impression that this is asking about whether Article 8 is perhaps becoming, is there any possibility it's becoming more generous? Unfortunately, my answer to that is no. If it's a spouse or a partner of a British national or a settled person in the UK, you need to show that you meet the requirements of Appendix FM. That's if you're here legally, then you would need to show the financial requirements, English language requirements. If you're making an application for entry clearance, the same. If you're here without leave to remain, here illegally, then you would be on a 10-year route to settlement, and you would need to show that there were insurmountable obstacles to your relationship continuing outside of the UK, or alternatively unjustifiably harsh consequences for you or another family member under Appendix FM Gen 3.2, Gen 3.3. So unfortunately, No, not really. Adam, can you think of anything?
Yeah, I presume this question is on the basis that somebody's here illegally and they're applying under the 10-year route. So obviously we're still, our first port of call is insurmountable obstacles. Have a look at, I don't know if I referred to it in my webinar, cases like LAL, GM Sri Lanka, which are helpful in the approach to insurmountable obstacles. I'd still, as I've said before, have a go at arguing that a sort of Chikwamba basis that, look, if I was to apply for entry clearance, I would, even though I'm making a 10-year application now, I would meet the immigration rules otherwise, because if there's not insurmountable obstacles, then at least you've got a potential Chikwamba argument. Obviously, the tribunal have been a bit tough on those kind of arguments following the case of Eunice, but it's worth throwing that in. But I think I agree with Priya, those who are here illegally with no children are in a difficult category, certainly.
Okay, we have a question here for you now, Adam. So what is the position in relation to asylum seekers arriving from EU countries and claiming asylum in the UK?
Yes, they make their asylum claim. I suppose you can apply for transfer of refugee status. It's not something I presume. Just tell me that question. Actually, I've got it in front of me. Asylum seekers arriving from EU countries. So, sorry, I was thinking transfer of refugee status if they've been recognised in another country before. But I presume if they're asylum seekers, they haven't been recognised before in the question. So you'd make your application in terms of, obviously, you know, we're not, you know, outside Europe now. The Dublin Convention has gone away, so I presume they would just have to be considered by the Home Office, unless the Home Office managed to get agreements, I suppose, with European states, and they would raise a Section 8 point that you went through a safe European country. So I presume the question is really asking what happens to cases that would have been processed under Dublin procedures previously. So I think you make your application. And just be prepared to deal as usual why, you know, they went through a safe third country. Priya, am I going mad in my answer to that question?
I thought it was simply asking about Dublin cases. That was my understanding of that question. So.
Okay, so in deportation matters, is the impact on older adults or parents of the deportee given consideration in relation to the unduly harsh threshold?
I can take that because I covered deportation in my session. So in section 117C, and the unduly harsh exception, so that's exception 2, relates to relationships with partners and children. Obviously, if you come to deal with the very compelling circumstances over and above, which would apply to cases over 4-year sentences, or those cases under 4 years and you can't succeed under the exceptions, relationships with adult children and with older adults to adult dependents would be part of a proportionality assessment, because that very compelling circumstances is a proportionality assessment. And in my webinar, I referred to that European Court of Human Rights case. And again, forgive me if I'm mispronouncing, Unani, where the European Court confirmed that the very compelling circumstances encompasses a fully orbed proportionality assessment with all the sort of principles that have been established in the historic case law. Yeah.
Okay. I would agree with all of that, yes.
Cool.
I'm just waiting for the next question. Bear with. Oh, no, that's not the next question. Maybe I'll go to a pre-recorded question. So, Adam, can you tell us a bit about the new visa scheme for young Indian professionals?
Yeah, I think that's something that's been causing a bit of a stir online since there was an announcement. So on the 4th of May 2021, the UK signed up to a migration and mobility partnership with India, and there's this provision for exchange of young professionals. If you have a look online, there's a memorandum of understanding, and Annex 1 sets out the provisions, but effectively it allows for a maximum of 3,000 people each year aged 18 to 30 to apply to come to the UK for up to 2 years and be able to work in the UK. So it's not yet in the immigration rules. We don't have a date for it coming online at the moment, but obviously I know there's a lot of hype because a lot of you will have clients who will have seen and heard of that and be very interested in it. I don't know how they're going to manage the 3,000, because 3,000 in Indian applications is going to be gone in seconds. But obviously previously with the previous caps, they had allocations at certain times, whether they'll do that. So certainly that's what's coming, but something to watch out for. But obviously, alongside that, for those in the UK, you've got the graduate route opening up in July this year anyway. So that's something else to be aware of, and quite a generous route. And I think if delegates are looking to get new clients, if you live in a student town, get your posters in the window saying, I can advise you about a new graduate route if you want to stay in the UK for another 2 or 3 years, because I think it's a good option.
Excellent. Next question in. Is it still possible to ask the Home Office to review a refusal whilst an appeal is pending and before a skeleton argument is submitted? Is it still worth an email?
I mean, I've had cases where I've certainly suggested that an email is sent to the Home Office saying that there's new evidence that addresses the points that they've raised, or that they failed to consider something that was quite significant before them. I mean, often they don't look at things. I have found that with appeal skeleton arguments, many appeals have been conceded. So it may well be that that is the best place to try to get a review from the Home Office. As I say, I've had a number of cases where they have reviewed. Adam, would you say that's your experience?
I think obviously the new system seems to be the ASA triggers. Well, it has to be reviewed now. That's part of the directions. The old sort of entry clearance managers review, and I'm not sure if that's gone away, but I think it's always worth an email, isn't it? It's not going to hurt to sort of, if there's clear and obvious errors or things that haven't been looked at, flag it up at an early stage and raise it. But I think Pri's absolutely right. Focus on that appeal skeleton argument, because that's when they have to review it. That said, we've all had those reviews that have been rubbish and haven't looked and engaged with your ASAs. So I still think, keep knocking on the door of the Home Office, especially when you've got clients putting pressure on. So it's always worth a go.
I'm just waiting for the next question to come through, so bear with. There's an admin team working in the background here.
If not, do you want to go to one of the pre-submitted questions, Lisa? Should we do one of those while we wait for them to come up?
Well, I just did that, and I got told that I shouldn't do that, but I'm happy to do that to keep it flowing, because I'm waiting for a question and there's nothing there. So, oh no, they've just popped one through, so thank you for that. So I have a case which was submitted for a non-EU national spouse and the child of an EU national. The child was granted and the mother's has been pending for nearly 6 months. Each time we follow this up, we receive a generic response to confirm that they cannot give an exact time frame for an outcome. What would be the next step to speed this up? I guess that is Priya, isn't it? Yeah.
I mean, it's been over 6 months, and I think their processing times are generally supposed to be around that. It might be time to send a reaction letter, particularly because actually there's a child that's being impacted by their failure to make a decision on the mother. That child is being potentially separated from one parent, one that's I assume in the UK, or alternatively being prevented from starting their life here with their parent that's whose application is not being decided. So I would probably say that's the best way to deal with it. It can also be worth making a complaint to the Home Office. I often find that does really trigger them to make decisions.
Okay. So next question in is, oh no, that's just disappeared, bear with. Could you briefly explain how a partner in a durable relationship with an EEA national who does not have a relevant document can now leave the UK and apply for a family permit under EUSS?
The certainly obviously in the in-country applications, it's problematic, but I think looking at Appendix EU FP, it does provide for durable partners who've previously been living in the United Kingdom for the requisite period of time to make the application. And sorry, I'm just trying to grab it up in front of me. So, and there's a definition there of it's in the Appendix EU FP, and the definition of a durable partner. So it says that the person is or was in a durable relationship with a relevant EEA citizen, with the couple having lived together in a relationship akin to marriage or civil partnership for at least 2 years, and B, where the applicant was resident in the UK and Islands as the durable partner of a relevant EEA citizen before the specified date. So that's what, 11 p.m. on the 31st December, sorry. The person held a relevant document as a durable partner of the relevant EEA citizen, or, and I suppose this is where we're going to come in, because they probably haven't got the document previously, or where there is evidence which satisfies the entry clearance officer that the applicant was otherwise lawfully resident in the UK and Islands for the relevant period before the specified date, or where the applicant relies on the relevant EEA citizen being a relevant person of Northern Ireland, there is evidence. So there is potential to apply under Appendix EU FP, look at that definition of a durable partner there, but I suppose they'll have to get a shift on in order to make that application.
Okay, thank you.
Durable
so what
problematic. Sorry, I was just going to say, Priya and I were chatting earlier today, and durable partners are generally problematic, I think, at the moment. So yeah.
Okay, thanks for clarifying. So next question, what can be done to deal with a situation where a father in family proceedings incorrectly states they have pre-settled and not settled status, so as to avoid the son obtaining British citizenship, and in turn the mother, and I've got reference here, looks like the client, regularising her status?
I can take that, Adam. So, I mean, really what should have happened in those family proceedings is there should have been a request. There can be what I think it's a form called EX660, where the family courts are effectively communicating with the Home Office to obtain information on the relevant individuals' nationalities and their immigration status. So really that's what should have happened in that case. The proper information should have been sought from the Home Office. It can be very problematic to rely on parents who have competing interests in family cases in terms of what they want for the children and indeed the other parent of the child. If that has occurred, then obviously if the father has settled status, then it's the case of you making the correct application for the child anyway. And if the child then obtains their nationality, then of course the mother will be able to regularize her status regardless.
Okay. Brilliant. Thanks, Priya. What is the last date to apply under EUSS from abroad for parents of EEA nationals?
I presume the applications under Appendix EUFP would be the 30th of June, subject to the normal policy, or unless there's reasonable grounds for not of applying earlier. So, yeah. Okay.
Next question in. So would students who are in the UK with exceptional assurance or 3C leave be eligible for the upcoming graduate route?
The last grant of leave under and I've had a discussion with somebody, and I don't know if it's the person asking the question. Certainly I've had a discussion with this with somebody. Now, to apply under the student route, your last grant of leave needs to be, to apply under the graduate route, your last grant of leave must have been as a Tier 4 student. Now, 3C obviously just extends your existing leave. So certainly that shouldn't be a problem. One of the issues I've sort of advised on is, say a student walks into your office today and their leave expires sometime in June. What I probably suggest is you make some sort of holding application, and then you can vary that to a graduate route application when it opens in the 1st of July, because their leave will have been statutorily extended. So 3C extends existing leave. What they would do about an exceptional assurance, I don't know. So have a look at the current guidance in terms of the coronavirus policy and whether they would accept it in those circumstances. And it may be worth a go because of the particular, compelling circumstances. And certainly in that policy, the coronavirus policy, they've encouraged people with exceptional assurances to be able to apply. So obviously an exceptional assurance is not leave extended under section 3C. It's a, who knows what an exceptional assurance is in law actually, but I'd certainly have a go. I'm more comfortable with 3C, exceptional assurance question mark, but have a go. I don't know, Priya, what your thoughts on that is.
I don't really have anything to add to that, Adam, but yeah, that was really full.
I'm just waiting for admin to send through the next question. So if we don't get that in a few seconds, we'll go
pre-submitted.
Yeah, they've just asked me not to do that, but I just want to keep this flowing and answer as many questions as we can.
That was one of the pre-submitted questions of what to do for a graduate. Somebody wants to apply into the graduate route whose leave expires before the graduate route launches in July. So that is, I think I would make some sort of holding application. So, yeah.
Question just in. So is the new graduate visa just for those that are graduating this year? And when does the course have to have started?
I think that's one for you again, Adam.
Yeah, so the graduate route, no, it's going to be a new route that applies and is not just, it's not just a one-off route for this year, but there is this successful, there are different requirements to get your points: the successful completion requirement, the qualification requirement, and the study in the UK requirement. And I know, without drilling down to the exact rule, and that you've got to completed as GR 4.2, the applicant must have successfully completed the course of study which was undertaken during their last grant of permission to study on the student route. And so it's got to be in their last grant under the student route that they achieved the qualification, and it's got to be at a certain level. And there's a length of course condition within the rules. So have a look at the graduate route, the rules. It's still in the statement of changes because obviously it's not live as part of the immigration rules, but if you go into the relevant statement of changes, you'll find it there. But no, it's not a one-off route just for this year. Okay, bear with me on this next one because it's quite a lengthy one. So what is the view of the panel in relation to recent media reports of EU citizens being detained at immigration centres and of people receiving letters advising them to register for the EU settlement scheme when the recipients of letters have been resident in the UK and in some cases for 40 or 50 years? What advice or action might be recommended?
I can start that, Adam. So if they have been detained and that appears to be completely on an unlawful basis, you do want to really be seriously thinking about an unlawful detention claim. It might be worth having a look at the case of Santos in looking at the sort of damages that can flow where an individual has EU law rights and they've been unlawfully detained. In respect of letters that are being sent out, again, it might be worth making complaints. You can also maybe consider raising something under the compensation scheme, dependent on your particular client's circumstances and the impact that might have had on a particular client. But you would need to have evidence of it having had a detrimental impact upon your client. Adam, can you think of anything to add to that?
No, not. I suppose if they've got pre-existing rights, then you would lodge that. If they are in a position that they need to register under the EU settlement scheme, perhaps they need to do that. But no, nothing to add in relation to that. But certainly, I think Priya's right. It's sort of, getting in there with that pre-action letter in relation to an unlawful detention claim, certainly.
Okay, we've got the next question in now. So would an EA national and their family member, and I've got spouse, both with settled status, need to get a visa before travelling to an EU country?
I'm not sure I've understood that, Adam.
So is it so I think it's somebody in the country, so you've got an EU national family and their family member, both with settled status, need to, so that's about it, that's about them traveling abroad in order to enter. So I don't know if something we can deal with, because it depends on the sort of post-Brexit visa regime for that country in particular, I think, certainly. So it's something worth checking, especially for the third country. You'd have thought the EU national wouldn't have a problem because they're still an EU national. If they're going to an EU country, it wouldn't be a problem. It may be an issue in terms of their non-EU, spouse and family member.
Okay, so Priya, this one's heading your way. So my client has reached 10 years long residence whilst his application for permission to appeal has been pending in the upper tribunal. How best can I address this issue?
Okay, so there is, did you say whilst the application for permission to appeal has been pending in the upper tribunal?
So has been pending in the upper tribunal, yeah. So the client has reached 10 years long residence whilst his application for permission to appeal has been pending in the upper tribunal. How best can I address this?
Okay. So there is a case called Birch that says that new matters do not apply in the upper tribunal. However, the correctness of that decision is something that is currently being litigated in the upper tribunal. And I have been told in another case that there's expected to be a decision coming out in the next few months that may say that Birch is incorrect. So it's probably worth you writing to the Home Office and saying that my client now qualifies under paragraph 276B on the grounds of 10 years long residence, and explaining how the requirements are met, and refer them to Birch. But in the alternative, say it's sensible that they give consent to it as a new matter anyway. Refer them to their own policy guidance on that in respect of the rights of appeals and what that says about how they should ordinarily give consent to new matters so that everything can be dealt with in one appeal. That's probably how I would say to deal with it. There is a case which raised this specific issue. It's OA, it's in the upper tribunal, and it's exactly this situation that occurred. So it's worth also considering that.
One thing OA did say, which is a bit of a frustrating one, is that even if they accept the new matter, the Home Office can give you limited leave and may still need you to pay your full application fee to get your indefinite leave to remain. So that is, if your client thinks that'll be a cheaper and quicker way to indefinite leave to remain, have a look at OA that Priya refers to, because they still may only get limited leave out of this appeal and then still have to put in their set LR in.
Right, bear with me on this one. Oh, sorry, Priya, you're going to step in?
No, I was just agreeing with Adam on that.
Perfect. This one's quite a long one, so bear with me on this. So I have a few clients that I applied for EUSS family permit applications. Those applications have been refused for different ridiculous reasons, and due to the long timescales of going through the appeal process, client decided to try with PAP letter follows with fresh application should PAP fails. Results for PAP were positive in all cases, and Home Office agreed to reconsider in 90 days. Now there is potential risk of missing the deadline for new application if reconsider decision is reached after the 30th of June 21 and it is negative. Can you advise the best action in this form?
I think certainly if it's a negative result, and it's on the eligibility requirements, you should get an appeal under the EU settlement scheme and administrative review rights. In terms of your ability, I think what the question is saying, well, if they delay the review, what happens? I can't make a new application. The Home Office policy on making applications outside the deadline of the 30th of June is actually very generous. And if you put in a late application and said, well, actually, the reasons why this is late was I was previously waiting for you and you delayed it, I don't think they would have a good basis to stop you putting in a late application. So actually the policy, I mean, it's the main settlement scheme policy, what is it, about the 200-page one, has a section on late applications. And I think it's quite generous. And I could see that being a ground in order to make a late application if it's down to the Home Office tardiness effectively in reconsidering.
Okay, happy to move on. So what is the panel's recommendation in relation to any concerns that a person may have been subject to coercion and control for financial gain by others? For example, modern day slavery work arrangements upon arrival in the UK.
Okay, so the Home Office have, they have in the UK what's called the National Referral Mechanism.
I think we've lost Priya for a while.
We've lost Priya. I'll pick it up of what she was about to say, certainly. So we've got the National Referral Mechanism, and certainly you can refer, and there's helplines there in order that the clients, or you can make a referral, that they have the competent authority, including the Home Office, the Red Cross, who can deal with that. So if you're concerned about something, I would advise the client in relation to that, and make a reference under the National Referral Mechanism, certainly. So that's something to do, and you can do it. So Priya, we lost you for a second. I just said, I sort of tried to pick up where you were going, that sort of making a reference and contacting the helpline under the NRM helpline. I don't know if you were going to say anything else in relation to that.
I mean, what I was going to say about that was that it's a two-stage process, so that at the first stage they consider whether there's reasonable grounds for suspecting that an individual has been a victim of modern slavery. That's quite a low threshold. And at the second stage they consider whether there are conclusive grounds for accepting that somebody has been a victim. That's considered on the standard of balance of probabilities. So it can be quite a lengthy process, but that is the correct process to try to refer any client through where there are those sorts of concerns. Thanks for picking that up, Adam.
No worries.
Glad to get you back so quickly. A client arrived in the UK as a fiance during the COVID-19 lockdown. Subsequently, their partner lost his job. Due to the lockdown, they have not been able to marry and are 6 months are due. Is an HR extension better than an assurance, or assurance then HR application?
I think my guess, I was just quickly pulling up the policy, that there is a section on this in the policy. If you haven't been able to marry, you can apply for an extension in order to do that. So certainly, and I think that is always, applying for an extension is always better than an exceptional assurance, because it keeps your leave extended in the United Kingdom, and you're in that stronger position. And so have a look at the coronavirus policy. I'm just scanning down now, but certainly there was a section within there if you hadn't been able to marry, in order to make that extension application. So it's worth, my view is it's worth making an application for an extension on that basis.
I would agree with that.
Yeah, it just says this: if you're here with 6 months leave as a fiance or proposed civil partner, and your wedding or civil ceremonies have been delayed due to coronavirus, you may request additional time to stay, is known as an exceptional assurance, and providing evidence when your wedding or civil partner ceremony will take place. Otherwise, you can apply to extend your stay for a further 6 months to allow the ceremony to take place. I would go for that latter option first, and applying, first, certainly.
Okay, next question in. Can a tier 1 investor apply to extend his first initial 3 years and 4 months after they finish 3 years in the UK?
I'll have a look. Hold on.
I was going to say exactly the same. It's one certainly that just needs to be looked up under the immigration rules in terms of what the investor can do in terms of actually extend your stay. You may be able to extend as a tier 1 investor visa. So certainly there looks like there are extension applications. There are different provisions.
Yes, I think that's what it is. Yeah, Adam, it depends on your circumstances in respect of your investments, basically, if that makes sense.
Yeah, I think that's one of those questions where it's one that needs a specific look at the individual circumstances applying to the rules. Yeah.
Okay. I've got no other question in at the minute, so I'm going to go to our preset because we've only got a few more minutes left for questions. So, Priya, in one of my cases, the Home Office have argued that the birth of a British child, whilst the appeal is pending, is a new matter and they will not give consent for this to be dealt with at the appeal. The applicant was pregnant to a British partner when the application and decision were made. How best can I address this?
Okay, that's something that it happens quite frequently, actually, and it's a really strange approach for the Home Office to take when an individual has been pregnant during the decision-making process and they've been aware of that. You would really want to push them on their policy. You would really want reasons as to why they're withholding consent, and you would then need to look at that against the policy guidance document. Generally speaking, what the policy guidance document says is that if you have raised the new matter and the Home Office haven't considered it in good time, then that's a good reason to give consent. It also talks about, as I've said previously, everything being dealt with at once. Now, if you've raised the matter in grounds of appeal, and that was many months ago, and they're only saying a few days before the hearing or a few weeks before the hearing that they're withholding consent, then that really isn't in accordance with their guidance potentially. So you might want to think about drafting a pre-action letter and maybe bringing a judicial review against the Home Office. It's also just in that situation so irrational too to take that approach, because effectively they're forcing you to make a separate application on that basis and obtain a new fee from you, although their guidance does say that if they haven't given consent, they may need to make a new decision on that matter anyway. So it may be that your client isn't forced to make a new application, although I suspect that what the Home Office would do would be to invite a new application on that basis.
Okay. Can non-EEA family members who are permanent residents apply for their current non-EEA spouses under the settlement scheme?
That's a durable. Oh no, non-EEA spouse.
No, so it looks like somebody who's got permanent residence as a family member wants to now bring their dependent spouse over. My view would they would probably have to apply under Appendix FM and not under the settlement scheme.
Yes, I would agree.
Okay. I've not got a question in the inbox, so we'll go back unless something pops up, but it's not there at the moment. So, Adam, can you clarify the difference between the unduly harsh test in deportation and the very compelling circumstances requirement?
Yeah, and of course, we talked a bit about this earlier, and there's been a lot of recent case law on unduly harsh and the very compelling circumstances. I suppose the leading case is HA Iraq. I understand the Home Office are appealing that to the Supreme Court. I don't know if they've got permission or not. Obviously, unduly harsh, you're looking, well, firstly, it's a focus on the child or the partner alone. It's not a balancing against the criminality, but there has to be that level beyond the sort of acceptable level of harshness. Now, what the courts have recently sort of cautioned against is having this notional comparator, because you'll still have a Home Office or judges saying, well, there's nothing out of the ordinary. Plenty of kids grow up in single parent families. No, you've got to look at the harshness on this child or this wife. And that's why you need to focus on getting that evidence. Now, very compelling over and above the exceptions is that something more requirement. Now, it may be that you managed, say you've got a sentence of over 4 years, you satisfy a judge that's unduly harsh, but you'd have to show those additional elements. It may be that you can't show unduly harsh, but you're saying there are other factors which render this very compelling. NA Pakistan, case from Lord Justice Jackson still is the leading case on that, and it is set out, but the bar is set very high. I was dealing with a tribunal case yesterday involving a 13-year sentence, and that's where we're in. We're very compelling circumstances, and it's probably the highest test in the immigration rules, so you're going to need something very, very significant in relation to those sort of deportation cases. But they're not impossible, and the public interest is not a fixity. And that Unani case in the European Court of Human Rights is quite helpful because that was over 4 years. And also the Akinyemi case, which talked about the public interest can be variable, where somebody who previously had a right to British citizenship but never applied. So, yeah, have a look at that.
I think we're coming up for last questions now. So following a conclusive grounds decision, the Home Office very rarely grants discretionary leave to remain in the UK until the asylum claim is considered. How lawful is this decision?
Well, it all depends on the particular client's circumstances. Yes. The basis on which an individual is entitled to discretionary leave following a positive conclusive grounds decision is either on the basis that they're seeking compensation if they need to remain in the UK to pursue that. And obviously, these days, there's quite that compensation claims can be pursued from abroad. Although you may have circumstances in which they really need to be proceedings in the UK face to face. Secondly, where they're assisting the police with their inquiries, and then finally where they need to remain here owing to their personal circumstances. Now, the third situation is the broadest one, and it includes their family circumstances, their state of health, their safety, and any other relevant factors. Usually health is one of the factors that's advanced quite strongly in respect of personal circumstances, because where individuals have been victims of modern slavery, often they have physical injuries and psychological injuries that need assistance in the UK. And the whole point of the trafficking convention and them having leave is that the UK is supposed to be assisting them with their recovery. And by sending them to the country often which the trafficking has occurred from, they're potentially not assisting them with their recovery and maybe their recovery to worsen. So all depends on the evidence that you have and your particular circumstances.
I think that's absolutely right. I think it's making that sort of the discretionary category that Priya referred to. I suppose if all failed, I've had a case recently where in the asylum appeal, we didn't succeed in the asylum aspect because of our vulnerabilities, which have been picked up in the trafficking. The judge allowed the case under 276 ADE. So that might be a way to go, certainly.
Okay, well, unfortunately, that's all we've got time for today. And can I offer an apology to any questions that we haven't got to, but I've just been told there's been a very large turnout today and the engagement's been very forthcoming. So I want to thank you for attending Law 2021 on behalf of the panel. Online Immigration Law Shape the Debate, which was sponsored by Trinity College London. Thank you to our expert speakers, Adam and Priya. Thank you. And don't forget to join the solicitors group Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for next time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. Feedback forms for this event will be sent out when the event closes. And by completing this, you'll receive your CPD certificate. Please don't forget to visit the online exhibition at thesolicitorsgroup.co.uk. And by visiting the exhibition, you can access the free 1-hour CPD webinar from our webinar learning catalogue. You can also visit our exhibitor profile for more information on Trinity College London CELT. I will stay on for a couple of minutes just in case there are any questions or if you would like further information and contact details again. Thanks to all for attending and have a great day.
Thanks, everyone.
Thank you.